I got to start the, I forgot to start the YouTube. Let me start that. While that's starting, okay. All right. Hopefully that's all working. If anybody knows, you can see it. My screen tells me we're now live on YouTube. So go back to my notes. There will be no recesses allowed except for emergencies. We'll see where everybody is at the end of the prosecution, where we're running on time. Might need to take a quick bathroom break. If we need to, we'll do that. But normally we don't stop. But other than that, there'll be no stops. Again, you will all, I assume, are familiar with the rules with the video competition. First of all, scoring panelists, if you unmute, will you tell me whether or not you see any conflicts? I should have asked that earlier when I had you on video. Any conflicts?
No.
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 Okay, thank you all. Okay. Did anybody, when you saw the video, the scoring panelists, any of the team members see any conflicts? Okay. If you have any disputes arising out of the competition, you need to bring those to my attention, and we'll follow the Zoom procedures for conflicts. Are all in the before the bar or in the bar disputes. There's no outside the bar disputes. You must comply with time requirements. If you don't, that will be or could affect your score. I can't say will. That's up to the scoring panels. Could affect your score. So if you go over time, that could affect your scores. We have a coach here, which is fine. You cannot communicate with your coach during this. You communicate as again the video Zoom rules. You could communicate by text with each other and those things that are allowed under the rules, but no other communication. Timekeepers will post the time in the chat room and can come on in the last few minutes and give that the last minute or so and give the actual signatures. Okay, so with that, prosecution, do you want to do introductions on your team?
Yes, sir.
My name is Bryn Berry, and I will be giving the opening, and I will be directing Kyle Kuzak and crossing Avery Becker.
My name is Johnny Flanagan, and I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins.
And I am Asher Goldberg, and I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Blake Van Owen, and I will be delivering the closing statement.
Okay, thank you. And witnesses for the prosecution. There we go.
I am Joel Doherty. I will be playing the role of Alex Cifuentes.
I'm Ellie Burton. I'll be playing the role of Jordan Markowitz.
And I'm Connor Pomenko, and I will be playing the role of Kyle Kuzak.
Thank you. And the defense attorneys, do you want to introduce yourselves?
Yes, Your Honor. I'm John Pumiali. I will be direct examining Taylor Perkins, cross-examining Alex Cifuentes, and delivering the opening statement.
Thank you.
I'm TJ Newman. I will be direct examining Professor Blake Van Owen and cross-examining Detective Jordan Markowitz.
Good morning, Your Honor. I'm Maya Geiger, and I'm going to be direct examining Avery Becker today and cross-examining Kyle Kuzak and delivering the closing argument today.
Okay, and your defense witnesses.
Good morning, Your Honor. My name is Camille Denman, and I will be playing the role of Avery Becker.
Good morning, Your Honor. My name is Bryn Geiger, and I will be playing the role of Taylor Perkins.
Good morning, Your Honor. My name is Kiara Warren, and I'll be playing the role of Blake Van Owen.
Okay, thank you very much. All right, so if you all raise your right hands. Team members, do you promise that the presentation you're about to give will faithfully, truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
And witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements? You will not add material facts or opinions which are not contained in the case problem, and you'll follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
All right. Any preliminary matters from the prosecution?
Yes, Your Honor. May I proceed?
You may.
Pursuant to Rule 4.6, we would like to introduce the stipulations to the court.
Any objection from the defense?
No, Your Honor.
Okay, the stipulations will be admitted.
No other pretrial motions, Your Honor.
And defense, is there any pretrial matters?
Yes, Your Honor, if I may.
Yes.
First, the court should already have a copy of the trial roster, which you provided in advance of the competition. Please let me know if you don't have it.
We actually were not given the trial rosters. That's why I asked you to put the names up. But thank you. Well, if we have an issue with names, I'll try to stop and make sure before we start each witness that I got the names and the scoring panels know the names. So thank you.
Thank you, Your Honor. I would also like to constructively provide a copy of the stipulations to Your Honor and inquire whether the juries have copies as well.
Myself and the jurors, scoring panelists have copies of the case material. So yes, they do have the stipulations. Thank you.
Thank you, Your Honor. We would ask permission to stay seated during our presentation for purposes of audiovisual quality during these proceedings.
You could sit, you could stand. I'll let you pretty much do it the way you want to do it, or whatever your coaches have taught you, where you're most comfortable. I'm certainly comfortable you sitting. So.
Thank you. Lastly, Your Honor, we would ask permission to raise our hand as we object in order to alert the court that we have an objection in lieu of standing, again, to maximize audiovisual quality.
That'll be fine. And say objection because I might be looking. Hang on a second. Do we know Melinda? I got it. Somebody, Melinda iPhone. Sorry, I get.
Yeah,
Yes.
That's me just trying to get better audio. It's Melinda Guthrie.
Oh, okay. Thanks. I'm sorry. What was your last thing? I apologize, counsel.
Yeah. Lastly, Your Honor, we would ask permission to raise our hand as we object in order to alert the court.
Yeah, that's fine. What I think I was about to say is, please say objection in case I don't happen to be looking at you. I should be, but if I miss that, also make sure you're unmuted if you're on the other side and say objection. And anyway, so okay. Anything else?
Of course. Thank you, Your Honor. I have no further preliminary matters.
Okay, so at this time, what I'm going to ask is that everybody shut up their video except for the prosecution presenter, opener, excuse me. So Ms. Berry, when you're ready, you may unmute yourself and begin your opening.
Just to let you know, there's going to be an announcement in like 2 or 3 minutes. So when that happens, I will just mute.
Oh, okay. So, all right, yeah, just stop. If hopefully that won't rattle you. If it's going to rattle you, go ahead and keep up unless it's real loud. Oh, I see announcements. I know what you mean. Okay, all right. Go ahead.
May it please the court. Your Honor, opposing counsel, members of the jury, thank you for being here today. I will start with a story. Once upon a time, there was a girl who loved mock trial. She could make up a closing just by listening to the opposing counsel's case. She knew what she wanted her witnesses to say, and she could make them say it like it was almost magical. She felt that because of this natural talent, she did not need to put in large amounts of work during practice. So she didn't. Her coach, however, disagreed. Her coach told her every day at practice that she needed to work harder and that real attorneys in real cases did not make up their stories on the spot because if they did, the judge and the jury would see right through them. This made the girl mad. It made her resent her coach for their constant provoking and pushing for her to be better. Their resentment festered and grew inside of the girl, and over the years she was in mock trial until they controlled her. After winning the Best Attorney Award at the mock trial regionals, the girl's coach once again got on her for lack of preparation. The girl's long retained resentment exploded and she grabbed a permanent marker. She walked up
So we have the world's longest announcements. Ms. Barry, Ms. Barry, are you okay with continuing? Do you want to start over? I'm going to give you that option. I thought it was going to be more brief, and it might make more sense for you to start over if you just so they hear it in total, if you don't mind. So timekeeper will just restart the 5 minutes. Okay, got you done. I probably should have just waited. I thought it was a brief set of announcements, so I apologize to you. I didn't mean to rattle you in the middle of your opening.
Thank you for waiting.
Oh, no problem. When you said 2 minutes, I should have just waited. I was assuming I've been at the Glenwood High School, and their announcements are usually shorter. But anyway, so Ms. Barry, are you prepared to present your opening? We'll start like we never did this before.
Okay.
Relax, breathe, go when you're ready.
May it please the court. Your Honor, opposing counsel, members of the jury, thank you for being here today. I will start with the story. Once upon a time, there was a girl who loved mock trial. She could make up a closing just to listen to the opposing counsel's case. She knew what she wanted her witness to say, and she could make them say it almost magically. She felt that because of this natural talent, she did not need to put in large amounts of work during practice, so she didn't. Her coach, however, disagreed. Her coach told her every practice that she needed to work harder and that real attorneys in real cases did not make up their stories on the spot, because if they did, the judge and the jury would see right through them. This made the girl mad. It made her resent her coach and their constant provoking and pushing her to be better. This resentment festered and grew inside of the girl until it controlled her. After winning the Best Attorney Award at the mock trial regionals, the girl's coach once again got on her for her lack of preparation. The girl's long retained resentment exploded, and she grabbed a permanent marker. She walked outside, walked up to her coach's beloved white Porsche, and wrote "Worst Attorney Award" across the hood. Her coach, who had followed her out, immediately kicked off her team. She went home and told her mom that she would get back at her coach if it was the last thing she did. Later, she confided in her friends who plans to trash her coach's house through a text message. Sure enough, on March 6, 2020, a masked and gloved figure matching the girl's exact figure was seen walking out to the coach's house, around the side gate and through the back door. Her coach, having been warned through the camera alerts and noises the girl might have been making, was ready and waiting with the knife upon her entrance. There was a scuffle near the back door that led to the transportation of the knife from the coach to the girl and ultimately the stabbing of the coach by the girl. The puncture made by the knife was fatal, and the girl's mock trial coach, for which she had held so much resentment for so long, was now dead. No reconciliation, no mock trial championships, no happily ever after. The girl in the story I have just told is Avery Becker, the defendant in the case here today. Avery Becker let her resentment control her and led her eventually to kill her mock trial coach, Mackenzie Brackman. Today, we will hear from 6 witnesses, 3 who will prove the story I just told and 3 who will deny it. We will first hear from Alex Fuentes, the fellow member and friend of Avery's mentioned in the story. Alex will confirm Mackenzie Brackman and Avery Becker's unfriendly relationship and provide evidence for Avery's intention to trash Coach Brackman's house. Second, we will hear from Detective Jordan Markowitz, an expert witness who will go into detail about the significant event on March 6th and the important events surrounding it, indicating the defendant, Avery Becker, as the perpetrator. Third, we will hear from CSR Kyle Kuzak in his opinions once again as an expert witness of the proceedings of the incident on the day of March 6, 2020, again pointing to the circumstances and figure of Avery Becker. Following, in any particular order, will be Avery Becker, the defendant herself, Taylor Perkins, another friend of Avery's and previous member of the mock trial team, and Professor Blake Van Owen, a professor in investigative crime scenes. Taylor Perkins will attest to Avery and Brackman's disagreeable relationship and assert her own opinions of contempt towards the victim. Blake Van Owen will try to prove that Avery Becker could not have been the murderer, who we discovered to have holes in his own investigation. Finally, Avery herself will be forced to relate her unfriendly relationship with Brackman and testify of her habit of letting her anger and resentment control her actions. Though it may feel like it, this is not fiction. It is not a mere story. It is a real case with real actions, real people, and real emotions. Someone murdered Mackenzie Brackman, and that person was Avery Becker. The prosecution provides more than sufficient evidence for Avery's tequila relationship with and feelings of intense resentment towards Mr. Brackman for similar situations where Avery lost control in the past, and for Avery's uncanny person and situation in relation to the perpetrator on the day of the homicide, March 6, 2020. Members of the jury, thank you again for being here today and for listening so attentively to the facts of the case as seen by the prosecution. I know we will make the right decision. Thank you.
Thank you, Ms. Berry. The defense opener,
Yes, thank you, Your Honor.
and how do you pronounce your last name?
Pumayali.
Bumiali. If I kill it, I might call you John. I don't want
No,
to.
it's totally fine. Thank you.
Whenever you're ready, you may proceed.
All right, thank you, Your Honor. In this case, we take a look at a horrible murder of a high school mock trial coach, Mackenzie Brackman. On March 6th, 2020, he was found dead in his home. The police, after a short investigation, rushing to get it wrong, jumped to the conclusion that he was stabbed to death by his former mock trial student, Avery Becker. Hi, I'm John Pumiali, and I will be giving the opening statement for the defense in this case. We are asking for you to truly see how Avery Becker is not guilty. There was a rocky past in the mock trial team, but that is expected. Uniting many teenagers under the supervision of limited adults is hard, and there will always be some rebellion creating conflicts, but never enough to end someone's life. The opposing counsel will take advantage of the past that Avery and Coach Brackman have had just because she doesn't belong in a societal system where she is expected to act like a robot and do her best under the constricting instructions of Coach Brackman. We all have a time in life where we just feel like we don't fit in, and that's okay, but it should never be enough to unrightfully send someone to jail. Young Becker has also had a few disagreements with Alex Cifuentes. Alex Cifuentes is currently a senior at the Colorado High School, which we will refer to in this case as the CHS. He was a passionate junior the year of the incident. Because of his relationship with Coach Brackman, he couldn't see this case in an unbiased way. He had gained a close connection with Coach Brackman, influencing Alex's point of view in this case. Due to his tainted perspective, he is an unreliable witness. Cifuentes looked up to Mr. Brackman and wanted what's best for him, but he also wanted what's best for himself. The defense has evidence to show how Alex Cifuentes is an unreliable source for this case. We are worried that his obsession with success has brought on heavy, dangerous emotions such as greed and the fear of failure. When influenced by such emotions, people will go far distances to ensure they get what they want. In for a penny, in for a pound, right? In this case, you will proceed to see faulty evidence that happens to favor the point of view of the prosecution. On top of unreliable evidence, the state will try to convince you that the unidentifiable figure in the videos is Avery Becker, with a highly common build. Kyle Kuzak and Jordan Markowitz are trying to solve this puzzle as quickly as they can, to rush to justice. But one wrong move and justice rapidly becomes the incorrect word for the outcome. Kyle Kuzak and Jordan Markowitz are rushing to get it wrong with puzzle pieces that don't even connect. Some puzzle pieces are unreliable as they are fake and manipulated. Avery Becker is an innocent civilian who graduated from CHS the same year as the killing. Is it acceptable to blame an innocent young adult for the killing of a man? A wrongly directed sentence could ruin the life of a brilliant young being. Judge, members of the jury, in front of you today, I ask you, would you hurt Avery Becker's future for the inability of accurate evidence presented by adult witnesses? I think not. My counsel will prove to you how this evidence is not enough to jump to such a huge conclusion. The evidence shows no confirmed identity of Avery Becker at the crime scene. No confirmed identity. Each of our witnesses will show that Becker is not guilty beyond a reasonable doubt. Our expert witness, Blake Van Owen, has an official report showing Avery's whereabouts with Taylor on the day of Brackman's death. Our witness, Taylor Perkins, will testify that Avery was with her during the day of the killing, therefore making it impossible for it to have been Avery. Thank you.
Oh, thank you, counsel. Okay, prosecution, first witness. So I'll need the attorney, the witness, and the cross attorney. And we'll get you guys all set up here. And then I want to make sure the scoring panelists are ready. So do I have any attorneys? There we go.
I can't start my video. It says the host has stopped video. So.
Impossible. There.
And there we go.
Okay. All right. I think we've given the scoring panelists enough time. If any scoring panelist isn't ready, let me know, but otherwise we're going to proceed. Prosecution may call their first witness.
The prosecution would like to call Alex Fuentes to the stand.
Okay. Mr. Fuentes, you remind you're still under oath.
Yes.
You may proceed.
Thank you. Good morning. Please state your name and spell your last name for the court.
Alex Cifuentes, Sifuentes.
Where do you currently go to school?
Colorado High School.
Are you involved in any extracurricular activities?
I am. I'm a proud member of our mock trial at our high school.
Do you know Avery Becker?
I do. We're teammates, very good friends.
Was Avery Becker also a member of mock trial?
He was.
Would you describe to the jury how Avery behaved as a team member?
Yeah. Avery, well, she was a good attorney. She always got good awards. She was never the best team member. She always left us in a state of panic when it came time for competitions, thanks to her lack of being prepared.
Would you describe her as a rival to the defendant?
No, never. We're really good teammates.
Who is Mr. Brackman?
Mr. Brackman was our beloved coach.
Can you describe the relationship between the defendant and Brackman from your point of view?
Yeah, from my point of view, let's just say the relationship was very, very rocky. They were always frustrated with each other.
Was there a time when the defendant was moved from the A team to the B team?
There was. Avery, I mean, she was like the 19th time, and Coach Brackman just had enough of it and he demoted her to the B team.
What happened as a result of this?
Avery became enraged, and then she came to our teammate Taylor Perkins and had her quit the team to get back onto the A team.
What did Mr. Brackman say about this?
Objection, Your Honor. Hearsay.
Hans?
Oh, yes, I'm sorry.
I'm going to respond to the objection, counsel.
Under Rule 804A4 is a hearsay exception because the declarant is unavailable due to death.
Response?
I withdraw the objection, Your Honor.
You withdraw it?
To restate my question,
Yes.
what did Mr. Brackman say about what Avery did?
He ended up letting her back on the team.
All right. After this, did Avery receive any awards?
She did. After she was let back on the team in the regional tournament, Avery won Best Attorney Award, Best Closing Argument Award.
What did Mr. Brackman say after Avery got these awards?
Yeah, so Mr. Brackman told Avery that what she did in that competition, while she won those awards, her lack of being prepared would be considered malpractice in the world. As a real attorney, you wouldn't be able just to waltz in and hope everything works out the best for your client. So Mr. Brackman was not happy with Avery.
How did the defendant respond to Mr. Brackman's statements?
Avery became enraged with Mr. Brackman. I mean, totally furious.
Did Avery do anything to?
Objection, Your Honor. Hearsay to the previous question and this question.
Would you finish? Can I hear your total question? I thought you were in the middle of the question. Let me make sure. What was your question again?
Said, how did the defendant respond to Mr. Brackman's statements?
Okay.
And
so the objection is hearsay. You want to respond to that?
I'd like to rephrase my question.
Okay.
What did Avery do in response to Mr. Brackman's statements?
She became enraged, walked out of the room with a Sharpie marker and wrote on his 1986 Porsche. It was Mr. Brackman's cherry ride, and she wrote Worst Attorney Award right over it.
What happened as a result of this vandalism?
Our coach, Mr. Brackman, kicked Avery off the team for good.
Did the defendant ever attempt to get back?
Yeah, she did. She came to me asking if I would go to Mr. Brackman and talk about getting her back on the team.
Permission to show the court Exhibit 14.
Permission granted.
Do you recognize Exhibit 14?
I do.
What is Exhibit 14?
Exhibit 14 is a screenshot of text messages between Avery Becker and I.
Is Exhibit 14 true and accurate?
It is.
I would like to move for admission of Exhibit 14 into evidence.
Is there any objection?
Yes, Your Honor. But before, could I please talk with my counsel?
Sure.
Thank you. The evidence lacks authenticity.
Response?
Yes, may I confer with my counsel?
You may.
It is authentic. We have verified with Alex that these are true and accurate statements and accurately reflect what Avery Becker sent to him.
Last word, counsel?
These are true.
No, sorry.
Oh, I'm sorry. I thought you.
John, last word. Yeah, John and Johnny. So, John, do you want to respond to that?
Yes, the evidence also lacks reliability on the Rule 901.
And how does it lack reliability under 901?
It is a telephone conversation, and it does not show. I mean, there is a lack of reliability because they are screenshots, as they could be manipulated.
Okay, based on the foundations laid so far, I'm going to sustain the objection based on the fact that we don't know whether or not these are the actual screenshots. You could lay that foundation and then reintroduce it if you want to.
All right. Alex, are these the actual screenshots that have not been tampered with in any way?
They are. They have not been tampered. They came from my very phone.
And this is exactly what you see from Avery Becker.
Precisely. Exactly the point.
Now I would move to admit Exhibit 14 as evidence.
Is there any further objection or any, with respect to Exhibit 14?
No further objections, Your Honor.
Okay. Based on the foundation just laid, I'll admit Exhibit 14.
Thank you. May I proceed?
You may.
Thank you. Will you please read these text messages to us?
Yes. They say, "Hey, Alex, it's Avery. Hey, what's up? I'm sure you're aware that I got kicked off the team. I'm pretty desperate to get back on. Is there any way you'd be willing to talk to Coach Brackman about having me back? I don't know. Coach is still pretty upset with you. Please, it's really important to me. I guess I could try. After the situation, I doubt anyone could change his mind. Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. What are you going to do to his house? I'm going to wait until he's at work, then break in and trash it." End quote.
Thank you. Lastly, do you know Blair Rollins?
I mean, not really. We go to the same high school together. I mean, I've seen him a couple of times just passing by in the halls, but not that much, no.
Did you ever at any time steal the defendant's phone and give it to Blair Rollins?
Never. That is outrageous.
Thank you. No further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Thank you. Today is February 26th, 2021, correct?
It is.
And you're aware that Mr. Backman was found dead March 6th?
Yes. May he rest in peace.
And just as a reference, you were a junior at the Colorado High School at the time, right?
I was, yeah.
You claimed that Coach Backman was amazing, right?
Yeah, it's just probably one of the best coaches we've had. Amazing.
And at the mock trial practices, more often than not, Avery was frustrated with Mr. Backman.
Yeah, very frustrated.
So from what you have seen, Avery didn't get along very well with Mr. Backman, correct?
No.
And you say that you and Avery were practically best friends?
We were.
Great. Could you say that you put more time into the mock trial team than Avery Becker did?
Way more time.
You came prepared nearly every session?
I did. Very, very prepared. Way more prepared than Avery.
Now, sorry. And you say she had come up with everything on the fly. Is that still sustained? Is that still accurate?
Yeah, most of the time she just come in, make things up. Yep.
And in your witness statement, you say Avery always played the victim and refused to work hard. Is that accurate?
She did.
In the beginning of your witness statement, you also say we were almost equally as skilled as team members, referring to you and Avery, correct?
That is just different types of being skilled, you know?
So in other words, you put many more hours into the team and hard work, yet you were equally skilled?
We did. I would say she had more of a talent at it, but didn't work hard versus me. I had to work hard in order to be as skilled as her.
And you say Avery won the Best Attorney Award and Best Closing Argument at the regional tournament. Is that right?
I do, from what I remember, yes.
So Avery won 2 major tournaments and you won none. As a contributing mock trial team member, did this make you upset?
It did. I don't think she won it for the right reasons. I mean, I work super hard. She just comes in and waltzes in and wins them. That's just one part of mock trial that I have issue with. But yeah, that is correct.
And besides Avery's relationship with Brackman, you still think highly of him. Could we say that you admired him?
Admired Avery?
Sorry, admired Brackman.
Mr. Brackman, sorry. Yeah, Mr. Brackman, he was a great coach, always did good things for his students, wanted us to be our best. I always will admire him.
And you believe that someone should rightfully have to pay for his death?
Yes.
Would you consider yourself an average phone user?
Yeah, I mean, in today's day and age, we're always using our phones. I'm pretty good with my phone.
So you got to make sure you have it available at most times. Is that correct?
Yes, but sometimes, we're human, we lose things, but most of the times I have it with me.
Of course. And would you consider it a coincidence that you didn't have your phone with you on the day of the interview?
No, I would not consider it a coincidence. It was an honest accident, a mistake.
And you just forgot to charge your phone? Is that how you not had your phone? How you forgot your phone, I guess?
I mean, our coach was dead. I had so much going on in my head. How can we remember everything? I mean, forgetting my phone, that's just one of the tragic downsides that resulted with Mr. Brackman's death. I mean, I'm devastated and my mind's, it's all over the place these days.
Of course. Thank you. No further questions, Your Honor.
Thank you, counsel. Is there any redirect?
Yes, Your Honor. Alex, was there any difference in between the messages you received from Avery and the messages that you gave to the police department?
No, there's no difference.
Thank you. No further redirect.
Objection, Your Honor.
Yes, what's your objection?
That question was out of the scope of the cross-examination.
Response?
I will withdraw the question.
Okay, the question is withdrawn and the answer is stricken. The jury is instructed to disregard. Any other redirect?
No, no, Your Honor. Thank you.
Mr. Flanagan, did you have any other redirect?
No further redirect.
Okay. So the witness is excused. And if we could set up for the next prosecution witness, let the scoring panelist score.
May I call my witness, Your Honor?
Yeah, let's make sure we get everybody. The witness may put their video on, and the crossing attorney may put their video on. All right, let's just give 1 second. I want to make sure. Let me write down names, and then we'll be ready to go here. So. Okay. Any scoring panelists isn't ready, let me know. You may commence your direct examination.
Thank you, Your Honor. Good morning. Please state your first name and spell your last name.
Jordan Markowitz, Markowitz.
And Ms. Markowitz, what is your profession?
I am a homicide detective with the Denver Police Department. I've been with the DPD for 13 years now, and I've been a detective for 7 years.
And what type of specialized training do you have as a detective?
I specialize with cell phone technology. I received a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. In order to receive this, I had to go through a 3-day course, and then I also had to pass a certification test. From this experience, I learned about different types of cell phone data that can be obtained. I learned about how to use software such as the Cellbrite system in order to obtain and download information from cell phones. I learned about different types of cell tower data or cell towers, and just how to download technology from cell phones.
And how do you use all this?
I use it all the time with detective work and with the police. I've had to download the contents of over hundreds of phones. I've used cell tower data in over 50 cases. I use it all the time.
And have you testified in court as an expert before?
I have, yes.
Your Honor, I move to admit Detective Jordan Markowitz as an expert in homicide investigation with extra training in cell phone technology and forensic data recovery.
Is there any objection?
Yes, Your Honor. I do not believe that Detective Markowitz has laid foundation that they have experience as a homicide that she has experience as a homicide investigator, and I would request that the prosecution limits the scope of Detective Markowitz's testimony to only include that cell phone tower analysis and what she learned in her course at the American Academy of Law Enforcement.
Response, counsel?
May I lay additional foundation?
Certainly.
Detective, approximately how many cases have you investigated as a homicide detective?
Hundreds. It's too many to count.
Objection, Your Honor. Assumes facts not in evidence. Is outside the scope of the case. Problem.
Are you saying that's an extrapolation objection, counsel?
Yes.
Okay. Off the clock. So for a minute, I got to pull up the rolls. Okay, Mr. Newman, please state the basis for your objection.
I believe that nowhere in the case problem does it say at all how many cases Detective Markowitz has been a part of, only how many she has used the cell phone technology on.
Okay, Mr. Goldberg, your response.
Well, I believe that it can be assumed that the detective investigated a sizable amount of cases because she has downloaded the contents of hundreds of phones and has used cell tower data on a regular basis.
I believe it is an unfair extrapolation because it does not, it can be assumed that that she has been a part of a large number of cases, but there is nowhere that gives any sort of number as to that. And I do not believe that the assumption that she has participated in a large number of cases is a fair one because it has zero basis in her witness statement.
Mr. Goldberg, is there anything in her statement that you can quote to the scoring master to make this ultimate decision that indicates that I think your question was how many cases you've investigated, and you said lots, hundreds, I think was your answer, something to that effect. Is there anything that supports that in her affidavit?
Well, she's downloaded the contents of literally hundreds of cell phones, that's a quote, and then has obtained and interpreted cell tower data in over 50 cases.
Okay, that's from her affidavit.
Yes.
Okay. So this is an instruction for the scoring panelist. You as the scoring panelist are the sole arbiters of this dispute based on your individual observations, good faith judgment, and consistent with the intent of this judicial process. You may decide first there was no extrapolation, or the statement was not an unfair extrapolation, or the question did not ask for an unfair extrapolation as it was not material, or the statement was an unfair extrapolation, or the question was asking for unfair extrapolation and as it was material. The ultimate decision is at the discretion of each of the scoring panelists. Consistent with your decision, you may award one or more points, deduct one or more points, or take no action at all with respect to any of the parties involved. If you determine there was no unfair extrapolation or that there was no question asking for unfair extrapolation, you may deduct one or more points from the objecting party if you believe the objection was not made in good faith, was improvident, or was poor sportsmanship. Your decision is final. Okay? So let's move on to the next question.
I move to admit Detective Markowitz as an expert in homicide investigation with extra training in cell phone technology and forensic data recovery.
What's the second one after the homicide investigation?
With extra training in cell phone technology and forensic data recovery.
Okay. Mr. Newman, do you have to still remain your objection, or?
I still believe that they have not laid proper foundation as to her training in homicide investigation.
May I lay the foundation, Your Honor?
Sure.
Under Rule 703.
So you're
under Rule 703.
Like clear, so we'll have the timers mixed up. You're going to argue you're not putting more evidence in. You said lay more foundation. I took that to be your, and I'm fine with you arguing. I just don't want the timers to be going because I thought you were going to ask questions. So,
sorry. Yes, I'd like to respond.
Okay. All right. So timers, if you took any time during that, please add it back. Go ahead.
Under Rule 703, an expert's testimony, or an expert can be an expert based on, or excuse me, 702 can be qualified as an expert by knowledge, skill, experience, training, or education. And since the detective has been a detective for 7 years, she would have the necessary experience and knowledge to be an expert in homicide, in being a homicide detective.
Nowhere in the case file does it say that she has been a homicide detective for those 7 years. She could be a detective of car theft for all the court knows.
Okay.
Your
Mr.
Honor, may I read the quote?
Hold on. I'm going to give you a chance to talk. So, Mr. Newman, I understand you say it's not a case problem, but what is your, based on the testimony presented? Because in this case, the case problem is not before the court. I need to know from the testimony presented, what's your argument as to why there is insufficient expertise in homicide investigation?
Based on the testimony presented to the court, it has not been established that she was a detective, that she was a homicide detective for any of those 7 years, or that she has any training, education, or experience in homicide, in being a homicide detective.
Okay. Mr. Goldberg.
It says in the statement, I am a homicide detective with the Denver Police Department, and I have been a detective for 7 years.
I'm going to give you the same caveat I gave to Mr. Newman. I don't care what the statement says. It has to be an evidence here for me to consider. Okay. So, did she testify to what you're saying?
Yes.
Okay. All right. Anything else? I didn't mean to cut you off, but you referred to the statement, and that's not an evidence for me to consider.
She did testify to having 7 years of experience as a detective.
As what?
As a homicide detective.
It's gone on long enough. I'm going to take your word for it and assume that if you asked that, that's what you would say. The 702 is in Colorado is a fairly, or in the mock trial rules, is a fairly broad expertise. It doesn't take a lot to be qualified as an expert. So I'm going to allow her to be qualified. It goes to weight, not admissibility. Mr. Newman, you could certainly explore that more in cross-examination. So I'm going to allow the qualifications in the fields requested.
Okay, thank you, Your Honor. Okay, Ms. Markowitz, let's talk about today's case. What happened on March 6th, 2020?
On March 6th, there was reported of a passing motorist. They witnessed someone lying face down in the doorway of their front porch. So the paramedics then came, and upon finding the victim, they called the police. And then I arrived on the scene about 2:20.
Your Honor, permission to show to the court what has been marked as exhibits 1 through 6.
Permission granted.
Okay. Do you recognize these pictures?
I do, yes.
And what are they?
Sorry, this is the scene as I saw it. This exhibit 1 is the victim lying face down in the doorway in a pool of blood. And we move down to exhibit 2. This is the victim again, lying face down. You can see the stab wound on the back. And this is a close-up of the stab wound. And this is, you can see all the blood as the victim's lying in. And this is the knife that as I saw it, laying by the victim. And the knife again.
Permission to admit exhibits 1 through 6 into evidence.
Is there any objection?
Yes, Your Honor. I do not believe they have laid proper foundation or authenticated the exhibits properly.
Response.
I believe the proper foundation was laid.
The detective testified that these are pictures of the victim and the knife that was found at the scene. The last one, I assume, was afterwards. It was taken from the scene, but it looked like the same knife. So I think there's sufficient foundation. I would admit exhibits 1 through 6.
Thank you, Your Honor. And Back to those exhibits real quick, trial technician.
I'm sorry, say it again.
Oh, I'm just asking if we can show the exhibits again.
Oh,
Okay. So the body was found right in front of the door, right?
Yes, that's how I saw it.
And where did it appear that the victim was coming from?
It appeared that the victim had been running out or leaving their house. To explain why they are face down. They must have gone stabbed from behind.
And what else did you notice about the residence from when you entered?
So I entered through the back door, and then through the back door I saw the kitchen, and the kitchen was in slight disarray, but I couldn't really tell if it was the normal state of the kitchen or if there was a struggle. On the counter in the kitchen, there was a knife block, and there was one missing knife from the block. There was an open slot, and then also there was an open drawer of knives. And then I moved over to a chair lying on the floor that had been knocked over, and there was a plate that was broken on the floor as well. I also observed, just to make sure the items were missing or damaged, because it could have been a robbery of some sort, but I didn't notice any valuables that were damaged or stolen. Everything was in its place, as far as I could tell.
Permission to show the court what has been marked as exhibits 7 through 9.
permission granted.
Do you recognize these pictures?
I do, yes. This is the kitchen as I saw it.
Permission to admit exhibits 7 through 9 into evidence?
I'm sorry, 7 through 9.
Yes.
Response.
No response, Your Honor.
Be no response. I take that as no objection. I will admit exhibit 7, 8, 9.
Thank you, Your Honor. What is this exhibit in front of you, exhibit 7? What is this?
This is, as I said before, the open knife drawer as I saw it in the kitchen.
Now, were there pictures that were taken at the crime scene that were lost?
Sorry, you cut out. Will you say that again?
Were there pictures at the crime scene that were taken that were lost?
Yes, there were. There were some pictures that have been taken of blood splatters that were corrupted and lost in the translation of everything.
Objection. The witness cannot testify as to these pictures as under Rule 1002, the best evidence rule.
Are you talking about the missing pictures?
Yes.
Okay. Response, Mr. Goldberg?
The witness was not testifying about them, just describing the course of her investigation.
Anything else, Mr. Newman?
No, I stand by my objection.
Okay, what I heard, and Mr. Newman, correct me if I heard this wrong, is the witness testified there were some pictures lost, but she wasn't testifying about the actual contents, but rather some evidence had been lost, I guess.
What I heard was that she was testifying as to the content of the images, such as blood spatter.
Well, I think she testified again. Mr. Newman, correct me if I'm wrong. And what I heard is that there were pictures of blood spatter that were lost, but you didn't testify as to what they showed, but just there were pictures of them. Do I misrecall that?
I believe that's correct. Yes.
I think she could testify that there were pictures of blood spatter that were lost. I agree she can't testify about what they would have shown. So to that level, I sustained the objection, but I will not strike her testimony at this point.
Thank you, Your Honor.
How much did these pictures that were lost influence your conclusions about this case?
You're muted, Ms. Burton.
Sorry. They had no influence on my conclusions about the case.
And what did you notice about the scene next?
So when I was walking around to go in the back door, I noticed that there was a ring, as we can see in Exhibit 1 in the front doorway. And then I walked around and I could see that there was also a ring that was facing towards, it was on the south side, facing the back gate. And there was also one by the back door where I entered.
And did you download the contents of the
Yes, I did. When I downloaded them, I was able to access Mackenzie Brackman's Ring account. And so then I was able to access his history.
permission to show to the court what's been marked as exhibits 10 through 13?
You have permission, and let's just pause for a second. We're missing a student apparently, so please stop the time. But what is Kira?
There's a maroon team member named Kiera who apparently got kicked out. Is Kiera here? And apparently can't get back in.
I haven't seen her try to be readmitted, Judge.
She is still trying to get back in right now. She had to restart her computer, but she's on her way.
Okay.
All right, she's not, is she a witness coming up?
Yes.
Are we okay with?
She's on the defense, sorry, so she has a little bit of time.
All right, so we're okay with proceeding without her being in, and let her know and make sure she stays in touch with the tournament coordinator if there's any problems, okay? Or let me know and I can be in touch with him. But otherwise, we'll go ahead and proceed. You may publish the exhibits that you were, thank you. You may publish the exhibits that you want to publish.
Thank you, Your Honor.
Put them up, please. Would you remind me what exhibits?
10 through 13.
Okay, thanks.
So what are these? Oh, don't show them yet. What are these videos?
These are the videos that I found, downloaded the contents on from Brackman's Ring account, the history.
All right. Permission to admit them into evidence?
Mr. Newman, objection?
Your Honor, I do not believe the proper foundation has been laid as to how Detective Markowitz obtained these videos.
Hold on, everybody, just for a second. Okay, we got Kira back in. All right. Response, Mr. Goldberg.
I can re-ask the question about where they came from.
I'm sorry, you could re-ask a question?
Yeah, about where they.
If you want to re-ask a question, feel free to go ahead and do that.
Okay. Where did these videos come from?
So as I said before, I downloaded the contents from Brackman's phone and I was able to access his Ring account. And then since he has an updated version of the Ring account, I was able to get into his history and find these videos.
Now, all right, I move to admit them into evidence.
I still do not believe that the proper foundation has been laid as to the manner by which Detective Markowitz obtained these records through downloading them.
I think that's good cross-examination, Mr. Newman, but I'm going to admit the exhibits.
Thank you, Your Honor. Now, if we could show those videos to the court, very short. And that's fine. We can move on from there.
Okay.
So what did those videos show?
Those videos, the first one was the intruder trying to enter through the front door, and then the second one was the intruder trying to enter through the side gate. Well, did enter through the side gate.
And what else did you learn from the contents of Brackman's phone?
So from downloading the contents, I was also able to, I noticed that there are a lot of text messages revolving something called mock trial. And as a detective, I looked at that and I found out that he was the coach for a mock trial team at Colorado High School. And so from that, I decided to contact the members of the mock trial team.
And who is Alex Cifuentes?
Alex Fuentes is the first student that I came in contact with who actually gave me a huge break in the case.
Exhibit 14 has already been admitted to evidence. Can you pull that up? Now, these are the pictures that Alex Cifuentes gave to you, correct?
Yes, in our, because I interviewed him and he, yes, these pictures.
All right, and what did you do after that?
So I tried to get in contact with Avery Becker and we had set up a scheduled time to meet. And then right before our scheduled time, her lawyer called me and just said that her was not able to come in and that all further communications were going to have to go through her lawyer.
Objection, Your Honor. This is hearsay as to what the lawyer said.
Okay. Mr. Goldberg?
This is a under 803.1, it's a present sense impression, explaining something that happened as the witness was going about their investigation.
Mr. Newman?
Allow me 1 second to confer with my counsel.
Sure.
All right. This is not a present sense impression, as it is not as this statement was not made directly after the declarant perceived it, and this is a statement by someone other than the declarant.
Anything else, Mr. Goldberg?
No, Your Honor, I stand by.
Well, I'm going to overrule the objection on different grounds under 801 D2. I think it's a statement by a party opponent or his agent, and therefore it's not hearsay. I'm going to admit it.
Your Honor. Okay. So moving on, would you please describe for the jury how call detail records work?
Yes, so the service provider of phones, they don't track records that are made through calls and texts. There's a record that's made because cell towers, they're able to track when a call is made and if the call was reached, sorry, how long the duration of that call was. And then also if there were texts made back and forth, they're able to track that and record that.
And what did you find about Avery Becker's phone?
Avery Becker's phone had some calls coming in, but it was clear that they were not received because there was not a duration. It was just, the call was just made. And then had a lot of, Avery Becker's phone also had a lot of texts coming in, but no texts or calls going on.
Okay. No further questions, Your Honor.
Thank you. Mr. Newman, cross-examination.
Yes, Your Honor. Did you subpoena Ring for Mr. Brackman's user account records?
Sorry, can you say that again? You cut off.
Did you subpoena Ring for Mr. Brackman's user account records?
Yes.
Your Honor, you made a witness statement in this. You say you just testified that you did subpoena Ring in this case, correct?
Sorry, I'm confused on what you mean by your question.
You went to Ring the company. You did not go to Ring the company and obtain Mr. Brackman's user account records, correct?
I did not do that, no. I am able to download information. I was able to obtain his username and password to get into his Ring account.
And it is possible that he did not have his notifications turned on, correct?
It's possible, I guess.
So it is possible that he could have been surprised by the intruder.
Yes.
And how large of an area can a cell tower cover?
It depends on the cell tower.
In an average urban area, how far can a cell tower cover?
A couple miles, I'd say. Depending on how large it is.
And is it possible for a phone to not connect to the nearest cell tower?
It is possible, but very unlikely. There's complex algorithm that goes into it, but basically when a call or a text is made, it almost always goes to the cell tower that it is closest to. It is very rare unless it's super, super busy.
But it is possible, correct?
Possible, yes, but very rare.
And it is possible for Avery Becker's phone to be several miles away from Mr. Brackman's house.
Based on the information that we received, it is possible, but again, we have records of calls and texts being made with this cell tower, and they were all going through these ones in this area.
But cell tower records do not show the exact location of a phone, correct?
Not the exact location, but around where the cell tower is, yes.
A 6 to 7 mile radius, correct?
Depends on the cell tower again, but sometimes.
At the very most, it can be up to 100 miles, correct?
Again, it depends on the cell tower.
And is it possible that somebody else could have had Mr. Becker's phone during the time of the murder?
You could say it's possible, but also very unlikely.
And do you realize that screenshots can be easily faked?
Yes, I realized that, but I interviewed Alex, and he told me that he would give me a screenshot of what he saw.
Yes, but without timestamps or access to Alex Cifuentes' phone, is it possible that the screenshots were fake?
Again, possible, but very unlikely.
Thank you, Your Honor. No further questions.
Mr. Newman, any other redirect or any redirect?
Yes, Your Honor. The text you what's the likelihood that those texts were faked?
Very unlikely.
Objection. She has not testified. This assumes facts, not an evidence. She has not testified as to how likely the texts were to be faked. Only if it's possible. Only its possibility.
So can I, Mr. Newman, is that another extrapolation objection?
No, that is an objection assuming facts, not an evidence. The question assumes facts, not an evidence.
Okay, thanks. Make sure I understand your objection. Mr. Goldberg, response.
I believe the facts are in evidence, and my question was within the scope of his cross-examination, my opposing counsel's cross-examination.
Yeah, it wasn't a scope issue. It was whether it's facts, not an evidence. Hold on 1 second. This witness is an expert witness and is qualified to give the opinion she just gave. So it goes to weight, not admissibility. I'm going to overrule the objection.
No further redirect, Your Honor.
Any recross?
No, Your Honor.
Okay, this witness is excused. And while the scoring panelists are scoring, if we could have the next prosecution witness get prepared so we're ready to go.
Your Honor, calling witness Kyle Kuzak to the stand.
Okay. Do we have that witness?
Yes, Your Honor.
Can you put your video on, please?
Yes, my apologies.
There we go. All right. That's what I couldn't see you.
Right.
Okay. 1 second before I get started. Scoring panelist, anybody not ready? All right. You may proceed, Ms. Berry.
Thank you. Mr. Kuzak, state your name and spell it for the court.
My name is Kyle Kuzak, K-U-Z-A-K.
Thank you. And what is your profession?
I am a certified crime scene investigator, also known as a CSR.
Thank you. And what education does it take to become a CSR?
In most cases, it requires at least a bachelor's degree.
Thank you. And how long have you employed in this line of work?
I have been in this work for the past 19 years.
Where are you currently employed?
I currently am a civilian at the police department, and I have been for the last 3 years.
Thank you. And how long have you been employed there?
For 3 years.
Thank you. And what types of crime scenes have you investigated in the past?
Oh, I've investigated loads of crime scenes, from house to home invasions to burglaries, and then over to stuff such as homicides, domestic violence, fatal accidents, and armed robberies.
Thank you. Your Honor, at this time, I'd like to move to admit Kyle Kuzak as an expert witness in crime scene reconstruction.
Any objection?
Yes, Your Honor. May I proceed with voir dire of the witness?
You may.
So, Mr. Kuzak, you're not a police officer, are you?
No, I'm not.
You're a civilian employee of the Denver Police Department?
I am that, as well as I still am a crime scene reconstruction investigator.
Right. But you've been working at the Denver Police Department for the past 3 years, right?
I have.
And you testified that you have 19 years of experience investigating crime scenes, right?
Yes, I do.
But we don't have a copy of your CV, including where you went to school, do we?
No, we don't.
And Your Honor, we object to qualifying Mr. Kuzak as an expert witness under Rule 702. The only information we have that he is certified in crime scene reconstruction with 19 years of experience is his own testimony. We don't know where the experience was, when or how he got certified, and what education he has.
Ms. Berry, response.
I believe his statement is enough.
So you believe that his testimony, is your assertion, his testimony says sufficient qualifications. Is that correct?
Yes, I don't think he would be hired for this job if he did not have any sort of expertise.
Last word, Ms. Geiger.
We don't know how he got hired and who hired him. We don't know if they had a bias when hiring him. We don't know where he got his education. And I still remain by my objection under Rule 702 that he should not be qualified as an expert.
Okay. Again, Rule 702, as I mentioned, the last expert is fairly, doesn't require a lot. It requires some extra skill and training. I think his testimony establishes that skill and training, and it goes to weight not admissibilities. You're certainly welcome to explore that lack of qualifications or training in cross. I'm going to allow the witness to testify in the field's office.
Okay, thank you, Your Honor.
Thank you. May I continue?
Yes.
Thank you. Mr. Kuzak, did you visit the crime scene in person?
Yes, I did.
And was this helpful for your investigation?
Yes, it allowed me to summarize the most important events as well as creating a chronological timeline of the events that happened.
Thank you. And what did the defendant do upon first entering the victim's property?
Well, when the intruder entered, they went to the front door and tried to get in that way. And then after that, they traveled around to the back door, which is where they ultimately entered the house.
Thank you. And what evidence do we have?
The ring security footage from the house.
Thank you. And what is the significance?
Well, the intruder seemed to, from my opinion, seemed to.
Hold on a second. Go ahead. Ms. Geiger, you have an objection?
Yes, objection under ambiguous. The question that the prosecution attorney just asked was very confusing and ambiguous, and I feel that the witness would not be able to answer it correctly due to its confusing nature.
Response, Ms. Berry?
Can you rephrase my question?
Sure.
Mr. Kuzak, according to your evidence found from the videos as seen in exhibits 10 through 13, what significance did you find?
Well, from my expert opinion, and what we saw, the intruder matched the defendant's height and build, as well as by analyzing their physical conduct, it seemed that the intruder was unaware that the victim was home at that time.
Thank you. And was Mr. Brackman aware of the defendant before her entrance?
Yes, he would have been aware.
And what evidence do we have of this?
Well, first of all, the ring security footage would have sent a notification on his phone, as well as the knife drawer was open, indicating that Brackman had likely armed himself before the intruder came into the home. There were also scuff marks next to the back door, which also is where Brackman would likely have heard the intruder coming in.
Thank you. And in your opinion, as an expert witness, what happened on March 6, 2020 at the home of Mackenzie Brackman?
From my expert opinion, on the day of March 6, 2020, at the residence of Mackenzie Brackman, a perpetrator matching very similar build of the defendant, Avery Becker, entered the home unaware that Brackman was present, with the initial intent to just trash the home, but then they were surprised to encounter the victim, which then led to a struggle, victim and the intruder, and which ended in Mackenzie Brackman's murder by the intruder, which was Avery Becker.
Thank you, Your Honor. No further questions.
Thank you, Ms. Berry. Mrs. Geiger, do you have cross?
Yes, Your Honor.
You may proceed.
Thank you. Mr. Kuzak, my name is Maya Geiger and I represent Ms. Becker, and I will be asking you some questions today. So you testified that you have 19 years of experience in investigating complex crime scenes
Yes, I do.
and that you're a certified crime scene reconstructioner.
Yep.
Okay.
Yes, I am.
You would agree that it is important to gather all relevant evidence, right?
It is important, although not necessary. It is important.
You don't think it's necessary to gather all relevant evidence?
Well, from the evidence that I found, although I do wish that I had more, it was completely enough for me to analyze and make into my 5-part analysis that I used to figure out and reconstruct the crime scene.
So you were saying the evidence that you reviewed for this case wasn't all relevant.
Rephrase that question.
You're saying that the evidence that you reviewed for this case wasn't all relevant based on what you just previously answered.
I do not believe that's what I intended to say. If that's what it is.
Right, okay. So would you also agree that it is absolutely crucial to conduct a thorough and comprehensive investigation before
Yes.
identifying the suspect?
Yes, and I always.
Okay, so let's talk about your conclusions in this case and what they were based upon. So you concluded that on March 6, 2020, a perpetrator matching the general height and build of the defendant approached the victim's residence, right?
Yes, that is correct.
Initially stepping on the front porch and checking the front door, right?
Yes,
And proceeding to the south side of the residence, right?
that is correct.
But the perpetrator was not identifiable on the ring videos, were they?
That is correct. They were completely covered.
And no DNA was recovered from the gate or the back door, was it?
Not from the intruder. No, there was not.
And no,
That's expected from something like this. It happens all the time.
and additionally, no fingerprints were recovered from the gate or back door either.
Yes, no, they were not.
And you can't tell by looking at the age of the perpetrator, right?
Sorry, we just had a bell. Could you say that question again?
Yeah, of course. So you can't tell by looking at the room footage the age of the perpetrator, right?
No, we can't. Sorry, pardon.
Please stop. Ms. Berry, if you'll let us know when we can proceed, that would be helpful.
You may proceed.
Okay, thank you.
Thank you.
Permission to repeat the question I just asked? As I was cut off.
Oh, yeah, yes.
Okay, so you can't tell by looking at the ring footage the age of the perpetrator, right?
No, we could not tell the age.
Or the gender
No,
or the race.
no.
And you testified that the individual in the video generally matched the height and build of Ms. Becker, right?
Yes, it was very similar.
But that height and build wasn't included in your findings, was it?
No, it was based on the evidence that I collected in my analysis.
But again, we don't have access to what that height and build actually was, do we?
No, we cannot be 100% sure.
Okay, so based on the physical evidence at the scene, you concluded that the victim must have been alerted by the ring's security system, right?
That as well as several others.
And then the victim grabbed a knife from his knife block.
Either that or there was also a drawer that was open that he could have gotten a knife from.
Right. And then the victim confronted the intruder in the kitchen, right?
Yes.
And then was disarmed by the intruder. And the intruder then, as part of a struggle, reached over and stabbed the victim in the upper back shoulder, right?
That is correct.
And before you made your conclusions, you interviewed Detective Markowitz, didn't you?
Stop, please. Are we ready?
Yes.
Okay.
All right, Ms. Geiger, please proceed.
Okay. So before you made your conclusions, you interviewed Detective Markowitz, didn't you?
Yes, we did talk. Yeah.
Okay. And in fact, the flowchart you made was partially derived from your interview with Detective Markowitz too, right?
I would say that, yes, but it was also my personal analysis.
Right. And you read his report too, right?
Sorry, can you repeat that?
You read Detective Markowitz's report too on this case, correct?
Oh, yes, I did.
And Detective Markowitz had a theory, didn't he, that Avery Becker was a suspect?
Yes.
And you were aware of that theory?
I was.
And that theory was even included in your flowchart, wasn't it?
Yes, it was.
Okay. So one of the ways you arrived at your conclusions was by organizing all your photographs into a spreadsheet to reveal a clear timeline, correct?
Yes, it was. Yes.
And that timeline indicated to you that the victim was stabbed near the kitchen, correct?
Objection, Your Honor. The evidence was not admitted that the attorney was referring to.
I don't need to admit any evidence for this. This is in his testimony.
Could you repeat your question, Ms. Geiger? I missed the question.
I asked that one of the ways you arrived at your conclusions was by organizing all your photographs into a spreadsheet to reveal a clear timeline, which is in his testimony.
And Ms. Berry, would you give me your objection again?
I do not believe my witness can testify to the spreadsheet as it is not admitted into evidence.
Response, Ms. Geiger?
This was in his witness statement, and I feel like he can testify to it as he wrote it in his witness statement and has prior knowledge to it. So I feel like a proper objection has not been made either.
I'm an overruling objection to mock trial competition. You're allowed to go beyond the scope of direct in the original cross. And so she's not limited by what you ask in direct. So I'm going to overrule the objection.
May I re-ask my question?
Yes.
Okay, so one of the ways you arrived at your conclusions was by organizing all your photographs into a spreadsheet to reveal a clear timeline, right?
Yes, that was just one of the ways.
And that timeline indicated to you that the victim was stabbed near the kitchen, right?
Yes,
And then proceeded to the front door and pulled the knife out and dropped it there, right?
that is what my analysis showed. Yes.
Okay, and some of the photos you reviewed for your investigation were blood droplets and blood cast off, correct?
Yes, some of them were corrected, but before I was able to analyze them.
Do you want me to rephrase the question? Re-ask the
Oh,
question?
yes. Sorry. Yeah, it cut out.
But those photos, you reviewed photos of blood cast off and blood droplets, correct?
Yes, I did review them.
And those photos were corrupted though, weren't they?
Yes, some of them were.
And we don't have them, right?
No, they are not here anymore.
The jury can't see them, correct?
Yeah, they are gone.
Okay, and you testified that the scuff marks on the kitchen floor near the back door indicate a struggle, correct?
Yes, that was one of my conclusions. So that could have possibly been a struggle when the intruder and the victim made contact.
Right, but you have no way of independently verifying the age of those scuff marks, do you?
There is no way to really do that, but from my analysis and my recognition, I was able to infer that.
But to reiterate, you didn't independently verify the age of those scuff marks, did you?
No, I did not.
Okay, and you opined that the knife block was missing a knife, correct?
Could you rephrase that? Or repeat it?
Said that the knife block was missing a knife, correct?
Oh, yes, it was.
Yeah, but you have no idea if that knife was lost on some other date, do you?
No, we do not know.
And the knife that killed Mackenzie Brackman didn't match the knives in the block, did it?
No, it did not.
Okay, and there was no evidence on scene that any of Mackenzie Brackman's personal items were destroyed or stolen, right?
I mean, besides from just messy kitchen, no, there were not any evidence that belonged to me.
Okay, and Mackenzie Brackman died of a single stab wound to his left scapula penetrating into his thoracic aorta, correct?
Yes, that is correct.
And the scapula is a bone, right?
Yes, it is. Well,
And based on the materials you reviewed, it would have been taken a great amount of force, wouldn't it have, to penetrate the scapula all the way into the aortic valve, correct?
I mean, going through a bone would probably be rather difficult, yes.
Okay. And you believe this fatal wound occurred during a struggle, correct?
Yes.
And the perpetrator all the way around and stabbed Mr. Brackman?
Can you repeat that?
So you stated that the perpetrator reached all the way around and saw Mr. Brackman, correct?
Yes, from my analysis, yes, that is what I believe happened.
Okay. However, you didn't gather any information about whether the suspect was taller or shorter than Mackenzie Brackman, did you?
No, other than just acknowledging that the height and build was similar to his.
Okay. And you also didn't know if the suspect would have been right or left-handed, did you?
No, there's no way to tell.
And you've concluded that Mr. Brackman himself reached around and pulled his own knife out of his shoulder.
Yes, he did, which led to him bleeding out and dying.
He did that after he was injured?
Yes, he did.
And okay, so the knife was inserted facing partially forward at an angle, correct?
Yes.
This would have taken a great amount of force to remove out of his own body, wouldn't it have?
Yes, but I assume at that time he was probably kicking, given he was just stabbed. So,
Okay.
but yes.
And you said that you dismissed the likelihood that an intruder stabbed the victim from behind while seated at the kitchen table because the victim would have been, right?
I mean, there's just so many ways he can be notified. I think it's just ridiculous that that conclusion would be made that he was stabbed in the back.
Oh, okay, but you have no idea what Mackenzie Brackman was doing when the intruder came into his house, do you?
Sorry, can you repeat that?
Yeah, of course. So you have no idea what Mackenzie Brackman was doing when the intruder came into his house, do you?
Well, we have ideas. We're not like 100% sure, but based on evidence, we have a pretty good idea.
But you don't know whether he was distracted listening to music or singing in the bathroom, right?
I mean, I guess it could have been, but
Yeah, okay. And you can't tell the exact location in the house of the stabbing, can you?
no, we cannot find the exact location.
Because there was no blood spray or blood splatter droplets until the victim pulled the knife out, correct?
That is correct.
And lastly, Mr. Cusack, your opinion on this case does not include who the killer was, does it?
Well, from my inference, I can make a expert opinion from my opinion, a reasonable inference for who it was.
Right, but your testimony doesn't include who the intruder was, does it?
No, it does not.
Because you can't make that opinion based on the physical evidence in this case, can you?
Well, it definitely helps, and I can make a reasonable reconstruction, but I cannot be 100% sure.
Okay, no further questions, Your Honor.
Thank you, Ms. Geiger. Great. Oops. Was that another bell? Let me know when we're ready, Ms. Berry.
You may continue.
Do you have any redirect, Ms. Berry?
Briefly. Okay, Mr. Cusack, what evidence, where are the possibilities that the knife could have come from in the kitchen?
The possibilities include the knife block as well as the open drawer that contains lots of knives in it.
Thank you. And what evidence do we have of Mr. Brackman's preparation? No,
Can you repeat that?
I think my time is up.
Okay. Yes.
Thank you. Ms. Geiger, do you have any recross based on the question that was asked?
No, Your Honor.
Okay. Prosecution, have any more witnesses?
No, Your Honor.
Okay. Let's get the first defense witness prepared. While we're getting that first defense witness up, scoring panelist, are you up to speed? And do you need a quick break or not?
Can you just give me like a minute just to, I didn't get their names in the front part, so I just want to make sure I can get that in real quick. Since I think this was a good break to do that. If you don't mind just giving me a minute for that.
No, scoring is very important. I want to make sure that you're in the right place. So
thank you.
Danielle, you okay?
Actually, if we could, can we Yeah, I accidentally deleted the names of the first two prosecution witnesses. Can we type those in the chat?
Yeah, if we could do it, the prosecution team, could you put the person and the person they were portraying, the student and the person they were portraying, the first two prosecution witnesses? Thank you, Daniel. Melinda, anything you have?
Yeah, I was hoping for a bathroom break if possible. So.
Okay, so what we're going to do is, I'd like the witness and the first defense witness, everybody to stay here. You guys, because you're off screen, you can use the restroom off screen, but we're going to take about 2 minutes and let the scoring panelists take a restroom break. But I'd like to get everybody here, so as soon as we get everybody back, we get started. We're running a little behind here, so, okay? Okay, Melinda's back, Diana and Danielle, you ready?
Okay, let me just make sure. Sorry, the scoring stuff is such a weird order. I just wanted to make sure. I didn't get Asher's last name. I don't know if it matters, Charlie, if I just can do the first name in the scoring.
No, we probably need a full name.
Okay,
I'm
so
sorry.
if
I thought I
he
wrote.
is there, I would love to get his last name.
So you.
I apologize.
Is Asher's last name?
Yeah.
Looks like Goldberg in the chat. Thank you.
Thank you. I appreciate it. I apologize for that.
Okay. Danielle, you ready? Danielle. Okay, we're just waiting. I think the scoring panel sits. Taking a break here, so.
I'm back. Sorry about that.
Oh, that's all right. No problem. I just want to make sure we had everybody before we get started. So, all right, we have all the scoring panelists back. Defense, are you ready to present your first witness?
Yes, Your Honor. The defense calls Avery Becker to the stand.
Ms. Becker.
Okay, so can you state and spell your full name for the record?
Yes, my name is Avery Becker, Becker.
And did you murder Coach Brackman?
No, I would never do anything to hurt Mr. Brackman.
Do you even know where Brackman lives?
No, I have no idea where he lives.
Okay, Avery. So let's discuss a little bit more about you. Where do you live?
I live in Denver, Colorado.
And where did you go to school last year?
Last year, I was a senior at Colorado High School.
Were you on any teams or in any clubs at the school?
Yes, I was on the mock trial team at Colorado High School for all 4 years.
And why did you decide to join the mock trial team at CHS?
Well, my best friend Taylor Perkins and I decided to join the mock trial team together when we were freshmen because we thought it'd be a fun way to get out of the house and spend some time together.
And who was the coach of the mock trial team?
The coach was Mr. Mackenzie Brackman.
And how did you feel about Coach Brackman?
Well, I wish that Mr. Brackman would have recognized that I was good. I just wanted him to respect me and that I was good. And he was a good coach. We didn't always get along, but he was a good coach and he figured out how to get us to a place where we could be competitive.
Okay, and how would you be described as a mock trial competitor?
I was really good. I was really good at thinking of things on the fly, and I was particularly good at cross and closings.
And how did your coach view you as a competitor?
I think Mr. Brackman knew I was good, but I don't think he understood me. I think he understood people who spent more time preparing instead of like me, and I can do things on the fly.
Objection, Your Honor. Speculation.
Response, Ms. Geiger?
She has a personal knowledge to answer this question. She spent much time with Coach Brackman and understands how he feels about her based on her experiences with him. So I don't believe this is speculation, as she has the prior knowledge to answer this question.
Very.
It is still an opinion, which means it's still a speculation.
Is it a proper lay opinion under Rule 701, Barry?
Under Rule 701C, it is not based on scientific technical. Actually,
Oh, that's fine.
I stand by my.
That part of the rule deals with the expert versus lay testimony. Does she have a sufficient knowledge base, which is rationally based on the witness's perception? Is that your objection? Correct?
Yeah.
Okay. All right. Anything else, Ms. Geiger?
I still feel like she has the knowledge to answer this. She's not making a conclusion about the case, making any scientific inferences. She's just talking about her relationship with her old mock trial coach, whom she spent many years with. And I think she has the knowledge to answer this.
I think she's established a basis of knowledge of of Mr. Brackman, the coach. It's her opinion as to what that is that goes to weight, not admissibility. And you certainly can cross on that, Ms. Berry. So I'm going to overrule your objection.
Thank you, Your Honor. Okay. So did you have any friends on the mock trial team?
Yes, my best friend Taylor Perkins was on the mock trial team with me.
And did you have anyone on the mock trial team you didn't necessarily get along with?
Ugh, yes. There's this kid on the mock trial team, Alex Cifuentes, and he likes to say that we're best friends. And I don't know why he says that because we never got along. But maybe that was my mistake because I knew who my friends were and I didn't just say who others were. But I'm not such a pragmatist.
Okay. And did you ever text Alex Cifuentes outside of mock trial?
No, I would not text him.
And okay, so moving on, after the regional mock trial tournament, can you tell me a little bit about what happened?
Regionals was so good. I won best closing and best attorney, but then I really thought Mr. Brackman would have been happy for me and recognized that I was right all along, that I could do things on the fly, but he really started laying into me at practice, and he said that it was kind of just a fluke that I won and that I didn't deserve to win because I was unprepared and that it wouldn't work in the real world to be unprepared. But I really just wanted him to recognize that I was good.
Okay. And after Brackman started laying into you, can you tell me about what happened?
Yes, I was really upset because I really want him to respect me as a good mock trial competitor, but he didn't, so I stormed out of practice.
And what happened when you stormed out of practice?
Well, when I stormed out of practice, I had been at the whiteboard and I was writing. We were doing this exercise that was like, write some things you did well and some things that you want to improve for next time. And I was just about to write the things I did well when Brackman started his critique. And anyway, and so I stormed out of practice and I was still holding this marker in my hand. And I'm very embarrassed and ashamed of this. It was very immature. And I took the marker and I wrote on his Porsche, I wrote Worst Attorney Award. And I found out later that it had been a permanent marker.
And when you damaged Brackman's car, were you aiming to cause permanent damage?
No, I was just emotional and I really just wanted him to know how I felt. And I really didn't think it was a permanent marker because I've been using it at the whiteboard.
Okay, and how did Brackman react to the damage to his car?
Well, Brackman followed me out when I stormed out, and I think he was going to apologize or something, but then he saw his car and he freaked out and he told me that I was lazy and that I was not, that he was tired of me, and he called Taylor a loser, and anyway, he kicked me off the team.
Okay, and what did you do after you got kicked off the team?
I was so upset. I went home and I was sobbing and I told my mom that Brackman had kicked me off the team and that I was very upset. But she helped me to calm down and I realized that what I needed to do was to apologize.
Okay, and how did you feel after damaging Brackman's car?
I felt terrible. I didn't mean to cause any permanent damage and I really just wanted him to recognize me and see that I was good.
And after damaging Brackman's car, what did you do to try to make up with him?
Well, I really wanted to apologize in person. So I went to his office and I spoke to his secretary. And I said that I wanted to speak to Mr. Brackman, but then she said that he was busy and he didn't want to see me. So I realized that maybe I wouldn't be able to apologize in person. So I sent him a text message and I said I was so sorry and if he would maybe please consider letting me back on the team. But he ignored me and I never responded.
Okay, so moving on, can you describe what happened on the day of March 5th, 2020?
Yes. On March 5th, 2020, I went to the Fry Shack with Taylor.
And who did you see at the Fry Shack?
Well, besides Taylor, we saw a couple other people from the CHS mock trial team. And that brown noser, Alex Cifuentes, he was there.
Okay, and aside from the events of March 5th, 2020, let's talk a little bit about Alex Cifuentes and his life at school from what you observed. Is there anyone in particular you always saw Alex Cifuentes hanging out with?
I tried not to pay too much attention to Alex because frankly, I didn't care. But I do know that he was friends with this one kid, Blair Rollins.
And can you tell me a little bit about what you know about Blair Rollins?
Yeah, Blair Rollins is approximately the same height and billed as me. And my attorney showed me the ring security videos, and it could as well have been Blair. And anyway, and I know that Blair Rollins' father was convicted on a case that Mr. Brackman tried.
Objection, Your Honor. Hearsay.
Judge?
I can move on.
Okay, I'll sustain the objection, and to the level there was a hearsay statement, it'll be stricken.
Okay, thank you, Your Honor. Okay, so moving on, can you tell me a little bit about the events following March 5th, 2020? When did you notice your phone was missing? What day?
Well, in the morning of March 6th, I woke up and I couldn't find my phone anywhere. And honestly, I think Alex Cifuentes stole my phone, but that's not relevant. And so I went over to my friend Taylor's house and we decided to skip school to look for my phone.
Okay, and were you with Taylor the entire day of March 6th, 2020?
Yes, we were looking for my phone.
And where did you and Taylor go for the entire day of March 6th, 2020?
We were trying to retrace my steps of where I'd been the day before, so we went to the mall and then we went to the Fry Shack.
And how did you and Taylor go about looking for your phone?
Well, so we went to places where I had been on the phone. And then Taylor called my phone a lot of times when we were trying to see if we could hear it, but we never found it.
Okay, and on that day, did your lost phone receive several calls from Taylor's phone?
Yes.
And did you ever do anything to Brackman besides accidentally writing on his car in permanent marker?
No, I would never do anything to hurt Brackman. And I felt so bad after I wrote on his car. And he was a good coach. And I can't believe that he's gone.
Okay, no further questions, Your Honor.
Thank you, Ms. Geiger. Ms. Berry, you have cross-examination?
Yes, Your Honor. Ms. Becker, your relationship with Mackenzie Brackman Your relationship with Mackenzie Brackman was unfriendly, wasn't it?
Yes, we had tension.
Thank you. And Mr. Brackman never acknowledged your strengths, did he?
No, he didn't.
And his misunderstanding and abuse of your natural talent made you pretty frustrated, didn't it?
I really wanted him to respect me, so yes, I would say I was frustrated.
And when Brackman bumped you down to the B team, you were angry, correct?
Yes.
And it added on to that already simmering resentment, didn't it?
I really wanted him to respect me. I wouldn't do anything to hurt him.
Yes or no? Can you answer yes or no to my question?
Oh, can you repeat the question?
Sorry. It added on to when the anger you felt when Mr. Brackman bumped you down to the B team really added on to that.
Improper characterization?
Sorry, can you say it again?
Improper characterization?
How's it improper characterization? Could you
He's
explain?
improperly characterizing my witness by saying she had smoldering anger towards her coach when there's no evidence to prove that, and she never testified that.
Response, Ms. Berry.
If she didn't, she can say that in response to my question. I'm just, yeah.
Yeah, I think it's proper cross-examination. I'm going to allow the question.
So yes or no, it added on to that already simmering resentment, didn't it?
No, I didn't resent him.
But you were frustrated by his mistreatment of your skills.
Yes, I was frustrated with him, but did not resent.
And when Mr. Brackman got on you again after winning your 2 awards, you lost control of your emotions, didn't you?
Yes.
And you drew on Mr. Brackman's Porsche Worst Attorney Award with a permanent marker.
Yes, but I didn't know it was a permanent marker at the time.
And you said earlier that you believed that it was an extra marker because you've been about to write on the board for your good and bad things you did. Yes?
Yes, that is correct.
Yes. And in your experience in an everyday high school, is it very common to find a permanent marker on an expo stand? A whiteboard stand?
Not particularly. I'd say they're usually expo markers.
Thank you. And when Mr. Brackman kicked you off the team, You told your mom that you would get back at Brackman if it was the last thing you did, didn't you?
I said that in frustration and emotion, and I feel so bad for writing on his car, and I would never do anything else that would hurt him.
Thank you. So looking back over your mock trial career, you sometimes allowed your resentment and frustration towards your mock trial coach, Mackenzie Brackman, to control you and cause you to do things that you would not have otherwise done, correct?
Really just that one time when I rode on his car, and we occasionally yelled at each other, but it was very limited, and I certainly wouldn't kill him, and I would never do anything else.
And also earlier, you said that you had never done anything to hurt Mr. Brackman in the past. But you wrote on his car, and that is something to hurt Mr. Brackman, isn't it?
I didn't mean to cause permanent damage, and I thought that if it had been an expo marker, it would have wiped right off. And I really just wanted him to see how I felt, and I didn't mean to cause permanent damage.
But you did allow your emotions to get the better of you.
Yes, and I regret it terribly, and I've really learned a lot from that experience, and I would never do that again.
Thank you. No further questions.
Thank you, Ms. Berry. Is there any redirect, Ms. Geiger?
Yes, Your Honor. Avery, would you ever try to hurt Coach Brackman?
No, I wouldn't. I rode in his car, and like I just said, I regret that terribly, and that really doesn't reflect who I am, and I didn't mean.
And when you wrote on Brackman's car, you weren't trying to cause permanent damage to Brackman himself. You were just damaging his car, correct?
That is correct.
No further questions.
Thank you. Any recross?
No, Your Honor. Thank you.
Thank you, Ms. Berry. Okay, so let's get the next defense witness ready, and we'll let the scoring panelists get the scores in. Scoring panelists all ready, or anybody need more time? Hearing nothing, we will may proceed to call your next witness.
Thank you, Your Honor. The defense calls Taylor Perkins.
Ms. Perkins, you're reminded you're still under oath. You may proceed.
Thank you, Your Honor. Ms. Perkins, please state your name and spell your last name for the record.
Taylor Perkins, Perkins.
May I call you Taylor?
Yes, you may.
Thank you. Do you know why you are here to testify today?
I do, yes. My best friend Avery Becker has been wrongly accused of murder. However, she couldn't have murdered Mackenzie Brackman because she was with me all day, March 6th on 2020.
Okay, let's back up a little bit. Where do you currently reside?
I'm currently in Boulder, Colorado, as I'm a freshman at CU Boulder.
Does that mean you were in high school last year?
Yes, I was. I attended Colorado High School, typically referred to as CHS.
At CHS, were you involved in any extracurricular activities?
I was. I was on the mock trial team with my best friend Avery Becker.
And who was your coach?
Our coach was a criminal defense lawyer named Mackenzie Brackman, who, if you ask me, was pretty mediocre.
Did you have the opportunity to observe Avery perform on the mock trial team?
Yes, I did, both at practices and at tournaments.
How was Avery's performance in the mock trial team?
Well, it was very obvious that Avery was the best lawyer on the team, even if she was unprepared.
Thank you. Did you have the opportunity to observe Coach Brackman's reactions to Avery when she came to practice late or unprepared?
Yes, more times than not, Mr. Brackman would get very angry at Avery. You could almost see the steam coming out of his ears.
Let's turn to a month before the regional tournament last year. Did you observe Avery at the mock trial practice?
I did, yes. She came to practice the most unprepared I've ever seen her, making things up on the fly and getting a little bit off topic, but still performing well.
What, if anything, did Coach Brackman do to Avery as a result?
Well, surprise, surprise, Mr. Brackman got mad and demoted Avery down to B team, which was very unfair because Avery deserved to be on A team.
What do you mean by B team?
Well, there were two teams on the mock trial team, the A team for the better players and the B team for the other lawyers.
And what did you do, if anything, after Avery was demoted?
Well, mock trial meant more to Avery than it ever did to me. And personally, I didn't want to be on the team if my best friend wasn't on there. So I decided to step down from mock trial team, giving Mr. Brackman no choice but to put Avery back onto the A team.
Did Avery tell you about the incident in mock trial practice where she wrote on Coach Brackman's car with a marker?
She did, yes. She talked to me that night.
What, if anything, did Avery tell you about the marker she used?
She specifically told me that she used a dry erase marker. Of course, we both later found out that it was a permanent marker, but it was an honest mistake on her part.
Thank you. Do you know Alex Cifuentes?
I do, yes. He went to my high school and is on my mock trial team.
Did you have the opportunity to observe Avery interact with Alex?
I did, yes.
Did they appear to you to be friends?
I mean, maybe on the surface they're okay, but they really didn't get along.
Okay, I want to turn to Thursday, March 5th, 2020. Did you see Avery that day?
I did, yes. She swung by my house and we played games on our phones for a while.
What did you do later that evening?
Well, we were kind of hungry, so we decided to go to the fry shack to get something to eat, which actually might have turned out to be a bad idea.
And why is that?
Well, while we were still eating, some of the members from the mock trial team came in.
Was Alex Cifuentes there?
Yes, he was. She was.
At some point, were the mock trial kids talking to Avery?
Yes, they were. They kept going on about how unfair it was that Avery was kicked off the mock trial team.
And how did Avery respond to what they were saying?
Well, obviously, Avery got upset and sort of stormed off to the bathroom, even leaving her phone at the table.
What, if anything, did you notice when Avery went to the bathroom?
Like I said, I noticed her phone still on the table, which was really rare since that thing was like a third kidney to her.
Thank you. And who, if anyone, stayed at the table when Avery went to the bathroom?
Alex Fuentes stayed at the table with me and kept talking about how unfair it was that Avery was kicked off the team. Personally, I wanted to punch him.
And what happened after this?
Next, Avery came back and we went to the malls for a little bit.
Did you notice anything about Avery's phone when you left the fry shack?
I think it was still on the table, but I'm not 100% sure.
Okay, and where did you go next?
Next, we went to the malls. That was right before they shut down, and life was so different.
Now, let's turn to the morning of March 6, 2020. Did you see Avery that day?
I did, yes. She came by my house to pick me up for school like she typically does.
And what, if anything, did you find out when Avery came to get you?
Well, she hadn't been answering any of my texts or phone calls the night before this morning, so I asked her about it, and that's when we both realized that her phone was missing.
So what did you do next?
Well, we'd already taken an English quiz earlier in the week, and our classes were pretty dry that day, so we decided to ditch school and go look for her phone.
And where did you go to look for the phone?
We went back to the mall and looked in every store that we had gone into the night before.
Did you find the phone at the mall?
No, unfortunately, we didn't. We burned the entire day looking for it.
And did you go anywhere else besides the mall?
We did, yes. I remembered seeing the phone on the fry shack the night before, so we went there to check with the staff.
Did you find the phone at the fry shack?
Unfortunately, no.
Were you with Avery Becker all day on March 6, 2020?
I was, yes, and the police are welcome to track my phone through where we went that day, which, by the way, they never did.
Did you and Avery ever go near Coach Brackman's house on March 6, 2020?
No, we didn't, and I'm really sorry that Mr. Brackman is dead, but it wasn't Avery.
All right, no further questions, Your Honor. Thank you.
Thank you. Mr. Flanagan, Cross?
Yes, Your Honor. You are friends with Avery Becker, correct?
I am, yes, she is my best friend.
Is it also correct that neither you or the defendant thought very highly of Mr. Brackman?
I didn't really mind him as a person. I just thought he was a pretty mediocre coach.
And is it correct that you find Avery to be the best on your mock trial team?
It's very obvious that Avery is the best on the mock trial team, yes.
And is it correct that you feel Avery feels this as well?
Yes.
Is it safe to say that you think that without Avery, the mock trial team wouldn't be good at all?
I would believe that it'd still be okay, but it wouldn't be as good as without Avery.
Is it correct that you saw that Avery and Mr. Brackman had a feud, so to speak?
They didn't really get along, but yeah, I guess.
And it is correct that Avery did play pranks on Mr. Brackman before the vandalism of Mr. Brackman's car.
No, not any serious pranks.
But Avery did nevertheless play pranks on Mr. Brackman even before the vandalism.
Sometimes, not.
Thank you, Your Honor. No further questions.
Thank you. Any redirect questions?
Yes, Your Honor.
You may proceed.
Like you were saying, you and Avery are friends, so you guys have a pretty calm and easygoing relationship, and you guys are teenagers. Would you describe Avery's personality as somebody with a tendency to do fun things?
Yeah, she was a very outgoing and fun person.
All right.
Objection. Speculation.
Your response?
Taylor Perkins was really close to Avery, so they were able to interact with each other, and she was able to make her own observations of Avery and their relationship, basically getting a good foundation on the actions that she might take, and so she is qualified to answer.
Anything else, Mr. Flanagan?
I stand by.
I'm going to overrule. I think that given their relationship, she could make that opinion. So,
thank you. No further questions, Your Honor.
any recross?
No, Your Honor.
Okay, this witness is excused and defense's next witness we get set up.
Your Honor, the defense calls Professor Blake Van Owen.
Okay, let's not get started yet. I just want to get set up. I want to make sure that scoring panel's set.
Yep. All right, Detective Van Owen.
Hold on.
Sorry.
We got to get names and all that stuff, so it takes a minute. Carrie, are you okay? Your connection's okay?
Yeah, it seems to be back to normal now, but let me know if it starts to get all weird.
I saw you pop out a couple times, so okay. If we have problems, we'll stop. So,
are we ready?
Let me just. I'm writing names down. I'm sorry, I was talking at the same time.
Right.
Can't do both. Scoring panelists, anybody not ready? Mr. Newman, you may proceed.
Thank you. Detective Van Owen, please state your name and spell your last for the record.
Blake Van Owen, VAN space OWEN, and I prefer to be called Professor Van Owen.
And what's your experience with police work?
I used to work for the Aurora Police Department for about 9 months between 2005 and 2006.
And did you do any continuing education?
Yes, I got my master's degree with the Ashford University's online program for criminal justice.
And what is your current occupation?
I'm a professor at CU Denver, and I teach a class on social justice and police practices.
And have you ever been qualified as an expert before?
Yes, I have. I have served as an expert in over 100 cases.
Your Honor, where you would like to qualify Professor Van Owen under Rule 702 as an expert in crime scene reconstructions, call detail records, forensic data recovery, police practices, and general investigation tactics.
Stop the clock. Could you say that a little bit slower, Mr. Newman? I missed that.
Yes. Crime scene reconstruction, call detail records, forensic data recovery, police practices, and investigation tactics.
Okay. Did you get all that, Mr. Glover?
Yes, Your Honor. No objection.
No objection. Okay. Witness will be so qualified and allowed to express opinions in those fields. Thank you.
Thank you. What materials in this case did you review?
I reviewed the police reports, the crime scene reconstruction by Mr. Kuzak, and the cell tower analysis and exhibits prepared by Detective Markowitz.
And your expert opinion, how was the investigation?
They definitely went for the easy route in this investigation. They cut corners, they rushed, and they ultimately came to an easy conclusion rather than following more avenues of investigation.
And how do you feel about going for an easy conclusion?
The easy conclusion often leads to a wrong one or an ambiguous, or it becomes ambiguous who the, or it becomes ambiguous who actually committed the crime.
And in your opinion, how do you believe they came to this conclusion?
I believe that they came to this conclusion when Detective Markowitz planted the idea of Avery Becker as a suspect in Kyle Kuzak's mind, and from there on, his analysis was colored, and he only tried to find information and facts that applied to Avery Becker being the person who committed the crime.
And Kuzak opines that there was a struggle. What support is there for that?
There isn't any concrete evidence of a struggle.
Kuzak uses scuff marks as his evidence for the struggle. How do you feel about those?
That evidence is extremely inconclusive. We have no way of knowing when those scuff marks were made. They could have been made 5 years ago for all we know. We can't carbon date scuff marks.
And is there any other major pieces of evidence you found to be inconclusive?
Yes, I found the evidence that it was believed that the knife or the murder weapon came from a knife block was very inconclusive because both the brand and the blade dimensions of the knife and the style did not fit the other uniform knives in that block.
Your Honor, permission to share this piece is marked as Exhibit 21.
You may.
Thank you. And what is Exhibit 21?
That is a picture of me holding the knife in the way I believe it could have been held.
And is this a fair and accurate representation of the way you believe the knife could have been held?
Yes, it is.
Your Honor, permission to admit what is previously marked as Exhibit 21 into evidence.
Any objection, Mr. Goldberg?
No objection, Your Honor.
Exhibit 21 will be admitted.
And with Exhibit 21, how would this have impacted the way the murder played out if this was the way that the knife was held?
The victim would have been sitting down and the intruder would have been standing over that victim.
And do you believe that the detectives considered Exhibit 21?
No, I believe they only considered one way of holding a knife, like in the shower scene from Psycho. But as we've just seen, there's another way to hold the knife, and in this case, the way that is shown in Exhibit 21 is more probable because the construction of the knife handle makes it more comfortable to hold it in that way.
And did Detective Markowitz miss anything important?
Detective Markowitz missed many important things. For example, Detective Markowitz did not deem it worthy to look into the full and complete user records from the Ring app. And so we can't know if the push notifications were even turned on. On top of that, Detective Markowitz only obtained the cell tower records for Avery Becker for a limited amount of time and area. And there are so many red flags in that statement just there. If Detective Markowitz were really interested in finding the proper suspect, they would have looked at many cell numbers in the area and found any with connection to Brackman. But it seems that Detective Markowitz already had their mind made up. And even if they didn't look at everybody, it would have been beneficial to at least look at Taylor Perkins to confirm or deny that Taylor Perkins was where she said she was with Avery at the time. But unfortunately, we're left with the Avery being the only cell tower record and the limited amount of time showing that there wasn't much, showing not a full story of where the phone was.
And can screenshots be faked?
Yes, they can quite easily. I'm quite shocked that they accepted screenshots as evidence.
And at the very most, what did the cell tower records show?
At the very most, they show that Avery Becker's phone connected to a cell tower near Mr. Brackman's house at the time of the murder.
And why does this really not even show that much?
Because in urban settings, cell towers can cover a 6 to 7 mile radius. And on top of that, phones don't always connect to the nearest cell tower. They connect to the one with the best connection.
And what do the call detail records support?
They do support that Avery Becker and Taylor Perkins were searching for Avery's phone at the time because of the unanswered outgoing calls from Taylor Perkins' phone to Avery Becker's.
And did you find any other suspects in your investigation that you believe the detectives missed?
Yes, I found one who used to go to CHS with far more motive than getting kicked off of a mock trial team. Their name was Blair Rollins.
And what evidence did you find to support this?
I found recordings from Blair Rollins' father, who was represented by Brackman in a case earlier. You can.
And do the call detail records also support this conclusion?
Yes, they supported that, or if Rollins were to go to Brackman's house, it would follow the same route.
And you said that you found some recordings, or did you find any recordings?
Yes, I did. I listened to recordings from Jonathan Rollins' trial.
Your Honor, permission to share was previously marked as Exhibit 22.
You may.
And
I'll get you back, Brackman, if it's the last thing I do.
And what is Exhibit 22 a recording of?
A recording from Jonathan Rollins' sentencing.
And is this a fair and accurate representation of the recording that you obtained from Jonathan Rollins' sentencing?
Yes.
Your Honor, permission to admit what is previously marked as Exhibit 22 into evidence?
Any objection, Mr. Goldberg?
No objection, Your Honor.
Exhibit 22 will be admitted.
Thank you. And then was there anything else that was similar with Rollins and Becker?
Yes, they both went to CHS and they both have a similar height and build, so it could have easily been Rollins in the ring footage rather than Becker.
And were there any other important facts that were missed?
Yes, Blair Rollins wasn't in school at the day of the murder, so Blair could have been at Brackman's house trying to kill Brackman. And also, mysteriously, Blair Rollins has pretty much disappeared from, or been hard to find after graduation from CHS.
And was Rollins friends with anybody in this case?
Yes, I found that Rollins was friends with Alex Cifuentes.
Thank you, Your Honor. No further questions.
Thank you, Mr. Newman. Goldberg, cross-examination.
Yes, Your Honor. May I proceed?
You may.
Ms. Van Owen, you left the police force because you disagreed with it, correct?
Yes,
And this was 15 years ago?
yes, it was.
And you have not been on a police force in that time, correct?
No, I have not.
And you are being paid for your services here today, correct?
Yes, I am. It's my job.
Objection, Your Honor. Relevance. I believe that whether Professor Van Owen is being paid for her services here today is completely irrelevant and will not assist the fact finder in deciding the case.
Mr. Goldberg, response.
It goes to the character of the witness showing. I have no response. I'll withdraw the question.
Okay, if you withdraw the question, it'll be withdrawn and the answer will be stricken.
Now, you know Kyle Kuzak, correct?
Yes, we've met a few times.
And you said in your statement that Cusack is a little egotistical, correct?
I would describe him in that way.
Are you biased against Cusack?
No,
And you know Detective Markowitz too, right?
yes, we've also met a few times.
And you called Detective Markowitz a defective, correct?
Yes,
If the trial technician could pull up Exhibit 7.
You have permission to do that if you're really waiting for me, so.
I can pull it up if your trial technician is not there.
Whatever works.
Why don't you go ahead and do that, Mr. Newman? So
Sorry, this has a couple. This has a couple exhibits on it. Just from my director, Markowitz, in my other role.
we're just looking at Exhibit 7 for purposes of the record. So go ahead.
So, Ms. Van Owen, are you aware that in your direct examination, you did not acknowledge Exhibit 7?
I am aware.
And are you aware that Kyle Cusack testified today that the knife very well could have come out of this drawer?
Yes, I missed most of that, but
Understood. And now, and then if we can look at Exhibit 9 over here.
Exhibit 9 is just the one on the right.
Well, my something's hiding it on mine, but there is a broken plate on the ground. Are you aware that your direct examination also does not acknowledge this broken plate?
yes, I am.
And can we pull up Exhibit 21? Now, this knife is of a different style than the one that killed Mackenzie Brackman, correct?
It is of a similar handle, which is the main point here.
Can we pull up Exhibit 6, I think? The knife in Exhibit 21 looks pretty different from the knife in these exhibits, correct?
Correct, but the shape of the handle is still similar.
And now, in your statement on the subject of Exhibit 22, you say that Jonathan Rollins yelled out that Brackman was going to die, correct?
Yes, I did.
Now, did the actual recording say anything about Brackman's death?
Sorry, could you repeat that question?
The actual recording, I'll get you back, Brackman, if it's the last thing I do. Does that have anything about Brackman's death in it?
Not word for word, but it can be interpreted.
No further questions, Your Honor.
Thank you. Mr. Newman, redirect.
Yes, Your Honor. Is it possible that Mr. Brackman could have knocked over the plate after he had been stabbed?
Yes, very possible.
Thank you, Your Honor. No further questions.
Thank you. Any recross based on that question?
No, Your Honor.
Okay. Does the defense have any further witnesses?
No, Your Honor.
Okay, so we're going to take a minute and let the scorers complete their scoring on this part, and then we'll get into closings. Are the scoring judges ready? Anybody that's not, I guess it's a better way. Okay, prosecution, you prepared to present your closing argument.
Yes, Your Honor.
I assume that's you, Mr. Goldberg.
Yes.
You may proceed when you're ready.
May it please the court. Your Honor, members of the jury and opposing counsel, we are here today because of resentment. Resentment is a fire that burns away truth, a poison that kills the conscience, and an acid that corrodes the foundations of justice. On March 6th, 2020, resentment claimed the life of Mackenzie Brackman. Enraged by her coach's constant pleas to take competition seriously, Avery Becker vandalized Brackman's car. Like any sane person, Brackman kicked Becker off of his team. Becker decided to get payback for the consequence she deserved. While in the process of vandalizing his house, because the car wasn't enough, Becker was surprised by Brackman. In the struggle, Brackman was killed by the knife he brought. Avery Becker is guilty of burglary in the second degree, having knowingly entered a dwelling unlawfully with the intent to commit criminal mischief. Avery Becker is guilty of murder in the first degree, having in the furtherance of committing second-degree burglary caused the death of a person. As the prosecution, we are given the burden of proof to prove to you, the jury, that these accusations are true beyond a reasonable doubt. I hope you'll agree that we have done so. You heard today that Alex Cifuentes, friend and teammate of the defendant, witnessed Avery's resentment firsthand. Becker acted like the victim when she was actually the cause of the problem, committed vandalism out of anger, and was prepared to take it one step further. No one could have imagined how many steps further Becker actually took it. You have heard today that Detective Jordan Markowitz, first on the scene, found that all the evidence pointed to Avery Becker. You heard that Kyle Kuzak used his experience to reconstruct the crime scene and concluded once again that Avery Becker killed Brackman. The evidence showed the order of events in which the crime took place and showed that it was the defendant that fit the picture. You have heard from Becker herself, who admits that she let her anger control her actions. You have heard from Taylor Perkins, the defendant's alibi, who is the defendant's partner in everything and would do anything for them. You have heard from Blake Van Owen that the prosecution's case was faulty, but Van Owen's case does not address a few important pieces of evidence that point to the defendant. If you find Avery Becker not guilty, you let a dangerous killer walk free. A person consumed by resentment. How many more lives would be taken? What atrocities would be committed because a resentful murderer was free? For the sake of all people, we ask that you find Avery Becker guilty.
Thank you. Defense.
Yes, Your Honor. May it please the court. This case comes down to a simple conclusion. The prosecution was rushing to get this case wrong. From the beginning, the investigation of this case was rushed, and several key pieces of evidence went mysteriously missing without further investigation. Why? Because they were rushing to charge my completely innocent client, Avery Becker, with a falsely accused murder. This all circulates back to a key point in this case. The prosecution was unable to present evidence that would prove beyond a reasonable doubt that my client has committed the crime she stands on trial for today. The evidence we have presented today proves beyond a doubt that Avery Becker was not there at the time of the murder of Mackenzie Brackman. In their investigation to get this case wrong, the prosecution heavily relied on evidence they received from their expert witness, Jordan Markowitz. However, they failed to investigate the shortcomings in their case that Jordan Markowitz left. The prosecution relied heavily on evidence from cell towers, in which Markowitz is an expert on, failing to mention that Markowitz received only a short education of 3 days to get a certificate in phone technology. Additionally, the investigation by Markowitz into Avery Becker's cell phone tower records proves Becker's statement that her phone was lost, proving that the evidence of cell tower records connected to Becker's phone were an inaccurate depiction of the real location of Becker, and additionally provides evidence that once again, Avery was not at Mackenzie Brackman's house at the time of his murder. Furthermore, the prosecution failed to realize the significance in the corruption of photos, which proves the carelessness taken in this investigation, and the lackluster investigation carried out by Jordan Markowitz, who conveniently lost key pieces of evidence in an important murder investigation, proving the lack of thought and attention put in by the prosecution as they carried out their investigation, rushing to get this case wrong. Kyle Kuzak, a forensic reconstructioner, rushed through their investigation of this case, in which Kuzak relied on photos of the crime scene that were conveniently corrupted. And furthermore, Kuzak failed to do further investigation by not recovering any DNA in his investigation of the crime scene, providing a lack of evidence for the prosecution, and again, making them unable to prove beyond reasonable doubt Avery Becker was there at the time of Mackenzie Brackman's murder, and calling into question the credibility of this witness who seemingly didn't care enough to collect crucial pieces of evidence, rushing to a wrong conclusion of this case. Alex Cifuentes provides a statement full of disinformation and lack of evidence. Cifuentes conveniently forgot to bring their phone into the police station, a phone they claimed had text from Becker, saying she was going to Mackenzie Brackman's house to commit the murder that day, when in reality, Avery didn't even know where Mackenzie Brackman lived. Alice conveniently forgetting his phone once again leads to a lack of evidence on the prosecution's side and their inability to prove that Avery Becker was at Mackenzie Brackman's house and responsible for his murder. Alex's statement, furthermore, disproves the validity and truthfulness of this witness for the prosecution, when in a world of easy photoshopping, the texts presented in Exhibit 14 are not reliable and makes for an untrustworthy witness on the side of the prosecution, as they were once again rushing to get this case wrong. Today, the prosecution has presented a case with unreliable witnesses and lackluster evidence. I now want to point your attention to the jury instructions presented on page 6 of the official case problem, and in particular, jury instruction number 2. Jury instruction number 2 states that the prosecution must prove beyond a reasonable doubt, based upon presentation of evidence and solely facts, that the defendant, Avery Becker, was guilty. It additionally asks you to look at the presentation of evidence and base your opinion of the case after the evidence or lack of evidence that was presented on the side of the prosecution. However, with the presentation of vague and speculative assertions, the prosecution has failed to present enough evidence today that would prove beyond a reasonable doubt that my client, Avery Becker, is guilty. In the end, we ask you to look at the argument presented by the prosecution as what it is: incomplete and full of holes, as they rush to get this case wrong and falsely accuse Avery Becker of committing a murder in which they have no real trustworthy evidence to prove beyond a reasonable doubt that Avery Becker was even at or near Mackenzie Brackman's house on the day of his murder. We ask you to return a verdict of not guilty. Thank you.
Thank you, Ms. Geiger. Anything further by their side? If not, the trial will be concluded. I would ask that, Ms. Goldberg, do you have anything else?
No, Your Honor.
Okay. I would ask that as the scoring panelists are finishing up the scoring and getting them submitted, that you all turn on your videos so we can chat with all of you. And as soon as the scoring panelists are done and have submitted their scores, I'm going to ask them to put on their videos so that we know they're finished. And I know you want to eat lunch, so we'll get you out of here fairly quickly. We will try to provide cryptic but short comments. Is everybody breathing now that you're finished? That first one, getting that first one under your belt is always the hardest one. So, you know, Okay. I'll assume all scoring panelists have submitted their scoring sheets. Ms. Ray, comments?
Okay, so I just wanted to say, you guys, I'm so sorry you have to do this by Zoom, you poor things, because I know it's just much more fun to be in the courtroom and doing it in person. I know I'm an attorney and I'm stuck doing evidentiary hearings on Zoom and it sucks. So I just want to say that, but I thought you all did so good. I just want to let you know that, because presenting a case via Zoom is very difficult. You know, it's just not the same. And I thought you all did really well. I thought you were all very professional. And I thought you guys all got your points across. I do want to mention a few things. Since I was a mock trial coach for years, of course, I'm going to just give you a few tips. Okay. One is slow down. I know I'm speaking fast. I do the same thing, right? But that is huge. You want to specifically in your opening and your closing to pause for emphasis. Asher, you did that a couple of times. Maya, you did that a couple of times, and it was very effective. I would have liked to see that even more. And I know your time is restricted to only like 5 minutes, but I would really like to see that a little bit more. And also the elements that you have to prove prosecution, I would have liked to see those more in your openings. You know, this is what you're looking for, jury, and here's how we're proving it. And defense, the same thing, but in reverse. Here are the elements, and here's how the prosecution can't prove their case. Okay. And the other one is just responding to objections. Just make sure you use the rule number, the language of the rule, and the facts. So for example, if it says objection speculation, under rule 702, this is not speculation because this witness has personal knowledge and this is why. Boom, boom, boom. Okay. And that will just really bring you from, you know, an 8 to a 10 or whatever it might be. Okay. So that's just really a little bit of I think some advice for you guys. I have really detailed notes. I don't know if it's proper, Charlie, if I could like type them up and even send them maybe to the coach. I don't know if that is proper, but I do have some stuff because there was a couple of objections that I would have liked to see, like a 403, more prejudicial than probative for those pictures that the prosecution entered. I would have loved to see banter on that between the prosecution and the defense, and maybe a 404 argument on the marking up the vehicle. So there's a couple of just ones. So I think, and there might be reasons why you didn't bring that up, but I would love to send some notes if I could. I don't know if that's,
We could probably send them to me, but I don't know if we give the coaches the time. But I guess by the end of the day, they could use them tomorrow. So feel free.
Yeah, I could do it real quick. I mean, it won't be long notes, but I think just a little bit of those, because I mean, I could go on forever. So
I can send them to Lance because I don't know who the team coaches are, because I don't know who the teams are, but we could make sure that your coaches get them. So
okay, great.
Okay.
Thanks.
Melinda.
Well, I don't think I can say it any better than Diana just did. I had some of the same concerns with the openings. Would like to have seen them draw out the specific elements that we were going to see just a little bit more, so that was fresh in the minds of the jury as they were going through and hearing the evidence. I saw some places where some objections could have been had that weren't, and there was a lack of confidence in dealing with the objections. But overall, I'm with Ms. Ray. Overall, it was remarkable. They really looked at the elements of their crime. They really looked at who their witnesses were, what the statements were, and really tried to bring that all out. And the professionalism was really there too. We didn't see any smirks, no attitudes anywhere. They really tried to do what an attorney does in the courtroom, and I was very impressed with them. Yeah, thank you.
Thank you very much. Danielle.
I agree with both of those points. I think you guys did fantastic. I think you tackled the technology hurdle perfectly. I guess you guys have had about a year's of experience with that now, so you're good at it. I was so impressed with how professional everybody was. You know, when I think of myself as a high schooler, I could not have done what all of you guys just did. So, you know, you guys should all be really proud of yourself. And, you know, I agree with both of Diana and Melinda's points. I think there were a couple missed opportunities, but you're nervous, you're in the moment, and that just happens. That's going to happen every time. So, you know, I think you guys did great, and I was super impressed.
Thank you. So I have about 20 minutes of comments, but I won't. No, seriously. First of all, I hope you all breathe. Have a good lunch. I'm going to give you a couple of comments, but do relax. This is difficult competition. I coached for almost 20 years, and I think the lunch break was probably the thing that everybody enjoyed the most. So I want you to do that. I'm just going to kind of echo a couple of things everybody else said. And it's interesting to sit in the presiding judge and do this. It's a little bit different perspective, but the biggest issue is that both raised by most of the scoring panels, and that is this idea of objecting. Objections are done for a number of reasons. One, you want to keep out evidence that you want to keep out. You got to be careful on that, but you want to try to keep it out. The second reason, sometimes you're just interrupting that flow. And so it helps. You get somebody and they got a good witness and they're rolling and they're doing their thing, and third objection in the middle, sometimes it just interferes with the flow. Having the rule numbers and understanding the languages, as Diana indicated, I think is really important. Objection under Rule 401, it's not relevant, or 402, it's not relevant. Objection under 701, it's not a proper lay opinion. By the way, it's not 702, as Ms. Ray indicated, that's experts. It's 701. I have to take that shot there. We do share office space. Just a couple of things.
I said 701. No, you're right. I did not. I said 702.
Watch and cross your open-ended questions. Let's see. Mr. Newman, I think you did this. You asked a question, is it possible? And so you don't want to ask an open-ended question on cross, because they can, in fact, the witness did this to you one time and you effectively came in and cut them off, which was good. I mean, you came back and got control, but is it possible that Blake, and I think it was something about the nearest cell tower, it was one of your questions. So you want to make it more of a statement and get him to agree with you rather than say, is it possible? That way you're controlling. In cross, you want to be controlling the witness. You don't want to let the witness control you. And the best way to do it is to ask questions that technically can only be answered yes or no. Ms. Geigers, are we sisters? You know what? I bet you both talk too fast at home too, because you both really talk fast. Okay. Yeah. And from an attorney standpoint, particularly cross, Maya, you really effective on your cross, but it was rapid fire questions are good, but they have to be enunciated. And I talk too fast. I drive court reporters who have to type on machines nuts. They can't do it as fast as I can talk. So I can tell you what you should do. I can't lead by example. And is it Bryn? Is that a pronounced first name? Bryn, when you're as a witness, you were very good, but it was you're off and got off and running. And also watch on the direct, the ping pong effect. Okay, one of the things that is question, answer. It sounds scripted. Question, think about it for a second. I know you don't have a lot of time. Both you guys were on directs in particular, were pushed for time, and that this problem is set up in a way it makes it difficult. But think for a second, act like, oh, I've never heard this question before, and then answer. It's much more effective. It helps in that direct, both the attorney and the witness in that regard. Ms. Berry, where are you? She's off screen, I can't see her. I wanted to look you in the eye and tell you that was an amazing job with direct on an expert witness to do it in the time frame that you got stuck with, because you didn't have anywhere near enough time for that witness. I wanted to congratulate you. That was a great job of taking limited time and doing that. For timekeepers, my suggestion is give them more breakdown of time. You put that time up, every couple of minutes, let them know, because I think, and I remember the attorney before Ms. Berry, and it wasn't your fault either. You had a difficult case, a lot of objections you had to deal with, but you got to watch that time. You can't leave that last attorney with so little time. Maybe that was your plan, but otherwise, I thought it was a great reaction by Ms. Berry. I think I've covered most things. The only other thing is watch, and there wasn't a lot of redirect, but watch and redirect. A lot of times in redirect, they're leading questions, and there were several leading questions on redirect. And when you cross, be real careful. You got the cross, oh my God, I'm done, I can relax. You can't relax. Listen to it, make sure it's within the scope of what you ask, because it is a limit at that point, and they aren't asking a leading question. Isn't it true? Blah, blah, blah. And a lot of times in redirect, you do it because it's not as scripted as the other stuff. Don't abandon your objections. The question on a paid expert is exactly a good question. And why is it? Goes to bias and credibility. almost any time on cross, if you get an objection to your question, your response should be, Your Honor, this goes to the bias and credibility of the witness. You're going to win most objections when you do that, when you respond to objection, when you're crossing somebody. So, oh, and then Ms. Geiger, on your closing, the only thing you want to be careful, you said one thing, and just for future reference, you said, we have proven beyond reasonable doubt. You don't have anything to prove as a defense. What you want to do is just reverse that sentence and say, the prosecution didn't prove beyond reasonable doubt because otherwise you're assuming a burden that a defendant doesn't have. So just might want to rephrase that one sentence in your closing. Excellent job. I really enjoyed watching all of you, and I agree. Doing it on Zoom is not good. And we at the state committee level, I guarantee you, we're looking forward to getting everybody back to the courtrooms next year. So hopefully that happens. So good luck to all of you.
Thank you. Thank you.
You're welcome.
Thank you.
Thank you.
Thank you.
Bye, guys.